All right, indeed it is. So let me just get my slideshow going. There we are. Everyone can see my slideshow, right? It's the full screen. All right, so guys, it's a pleasure to see everyone here today and to have you all with me. For some reason, because of the way I have my slides, I can't see chats. So I will take questions at the end. Today's session, March 10th, is, first of all, some administrative notes. As always, this is being recorded. Anything that is said, be advised that this will be released in public forums, not just on our private forum, private Facebook forum. So be advised of that too. We're almost at 10,000 members. We're about 100 people away, I think, from 10,000 members. So that's really exciting. Thank you for everyone for making a difference. I am here to talk today about a subject that's vastly different than what we've talked about in the past, because usually we're very specific on individual instances, the analysis of the OREA form, assignments, taxation, whatever it may be that we've talked about in the past. Today, we're going to talk about the Canadian Constitution and Canadian history. Sorry, guys, I'm going to ask everyone please to mute if you don't mind. Today, I'm going to talk about the Canadian Constitution and Canadian history and how that relates to real estate. And, you know, I was thinking about it, and some of you may ask, well, why are we talking about this at all? Like, this doesn't help me with my deals. And actually, it really does. Many of you are involved in organized real estate, in the boards, in the OREA and TREB and everything else, and understanding how it kind of all fits together and where the requisite powers come from is really critical to understanding how we as an organized profession can move forward. But in addition, it's important because there are many individual instances where you may be dealing with things like human rights complaints or anything else in the tenancy aspects of law, and all of these things require an understanding of what the law is and where it derives from. So I'm really thrilled that all of you are joining me here today. It's really exciting. And without further ado, I'm now going to get started. And I'm again going to move back to my slideshow. Okay, here we are. So let's start with Canadian history. So as you're aware, in the 1300s, we were all living in our dark ages, though, by the way, recent historians have discovered that perhaps there were no dark ages at all. And in fact, perhaps we missed about 100 or 200 years. It's actually an interesting dialogue taking place amongst historians now. But that's neither here nor there. Basically, we came from squalor. And then one day, some Europeans discovered some land that was already occupied by others and decided to sail some ships over. Now, what you should understand about the British and the French at that time, and we're just going into history right now, what you should understand about British, French, and other colonial powers, particularly in the 1600s, once the Dutch began colonizing and the Spanish and the like, there was a general rule that existed for colonial powers, and it went like this. It said that those places that already had existing people living there were allowed, once conquered, to maintain their own law. Those places that were virgin territory, virgin in quotation marks, had to adopt the law of the reigning monarch that had just colonized the place. The Aboriginals were not recognized as people or colonizers of land by the French, by the English, by the Dutch, or anyone else, or the Spanish, or anyone else that tried to conquer these lands. And as a result, these lands were largely seen as virgin territory. I'm not saying this is right. I'm saying this is what was done. These lands were seen as virgin territory, and thus, when the British Crown or the French Empire staked their claim, all of the laws of France and Britain and all of the permutations of those laws were immediately transmuted into the land that was North America. And of course, the British and the French used North America and fought back and forth. Of course, the Spanish were there and a bunch of others, the Dutch and some others. But really, it became a battle as between the French and the British, who saw particularly the land that we presently call Canada as grounds for their battle. And they went ahead and they fought back and forth until the Battle of the Plains of Abraham. By the way, this is all taught in our history books, largely in grade 7. And it's really a shame that, Canadians don't take more pride in their history and understand their history. But hopefully you guys are not of that same ilk. We live in, I think, personally, the best country in the world. And understanding the history and how we got there is part of that. Regardless, in the battles of the Plains of Abraham, which took place in 1759, British emerged victorious and then said, okay, well, what the heck do we do with all this land that we've owned? And of course, when they remained victorious, they weren't victorious over all of Canada. They were victorious over the vast amount of land that would eventually become the nugget of Canada at that time. And so they passed shortly after the Battle of the Plains of Abraham. They had these decisions as to what to do. And they passed in 1763, the Royal Proclamation. And what it did was it established New France as its own distinct province. And at that time, it basically said, all right, these provisions, you remember how I said, when you conquer a land that already has an established legal code, you abide and you maintain that legal code. So in this instance, because they conquered French territory, they adhered to the French legal code. Until 1774, when they passed what's called the Quebec Act. The Quebec Act did several things. Firstly, it redefined criminal law to be under the British Civil Code, the British Common Law, excuse me, but it allowed the French to maintain their civil code for all things that were not criminal in nature. More importantly, it went ahead and it expanded Quebec into significantly down south. And if you take a look at the date, it's actually 1774 is a pretty familiar date for us because most of us, even those of us who are not American, understand that something very monumental took place but 2 years later, 1776, the American Revolution. It's often said, although not many people recognize this, that the Quebec Act directly instigated the American revolutionaries who said, look, these are expanding. The British are continuing to make rules without any representation or without consultation. They're expanding these French people down into our territories. Time for rebellion. And that's actually what happened in 1776. And of course, what happened when the Americans rebelled is that a whole bunch of people who preferred to be British subjects then flooded back up into Canada. And that resulted in the first mass migration to Canada that took place. Well, I guess the first one was the British settlers, but that really wasn't too much. Really, Canada got its first population boom as a result of the American Revolution in 1776, and the Americans, having successfully revolted against the British, started saying, you know what? We really can be taking over more of this. And the British were very worried because, of course, they had just lost their first battle. So a treaty was quickly reached with the Americans who needed to regroup. And the Treaty of Paris established a peace between Britain and the US, allowing the US to go on its merry way. Of course, the British then said, okay, well, what do we do with the land we have left? The Americans have just successfully, the American Revolution was a huge knock to the British esteem. And as a result, the British said, well, what do we do now? How do we avoid the future American conquest? And so they divided the remainder in 1784. They divided the remainder of their colonial assets into two distinct provinces called Upper Canada and Lower Canada. Many of you may be familiar with this, particularly if there's lawyers here, because until about 2 years ago, we belonged to what was called the Law Society of Upper Canada. It showed there's a reason that lawyers can't get rid of faxes. I mean, we couldn't get rid of the term Upper Canada until 2 years ago. So by that timeline, faxes really should take us another 200 years and we should be fine. Regardless, we divide into two different provinces, Upper Canada, Lower Canada. But even amongst the people who went ahead and produced the Treaty of Paris, even amongst the people who went ahead and divided the land of Canada into Upper and Lower Canada, everyone at the time believed that the status quo was not to prevail. In fact, amongst the Americans, once they got their feet on the ground and started owning their own country, there was a palpable sense that we did it once, we can do it again. And in fact, in the 1800s, this kind of came to a head through the Manifest Destiny movement. I don't know how many of you have studied the racist sentiments of Herbert Spencer as a historical basis, like Herbert Spencer and the like, that kind of came to the fore. But there was a palpable sense amongst the Americans that no other person but themselves should be ruling the entirety of the continents of North and South America. And if we were doing an American sort of analysis, we would start examining how the expansion started to rapidly take place south and west, which is really where their efforts were. In other words, the reason that they weren't approaching Canada is because why take Canada when you could take California? Most of their efforts were involved in taking things further south and further west, but Britain was always eyed as an
day or so.
Sorry, someone needs to mute. I'm sorry, guys. I don't have access to Zoom while I'm doing this particular presentation, so please mute yourself. So Britain was always seen as an unfinished matter that was going to require the Americans to invade at a later time. And if that was the sentiment, what happened just in a larger global historical conquest is you have your king, you have your French king, you have your French Revolution, then the Americans are inspired by the French Revolution. They're also infuriated by the British actions with the Treaty of Paris. They get scared, and as a result, they start saying, we need fortifications and land. And so what happened in Ontario at that time was quite interesting, or what happened in the Upper Canada at that time was quite interesting. Specifically, this wonderful person named John Graves Simcoe, who was actually Upper Canada's first governor, came around and said, you know what, we have a real problem, because in addition to the fact that the Americans have an appetite that is expanding further south and expanding further west, up north here, sure, we have a bunch of colonists that want to remain British, but they don't really have any interest in land. They don't have anything that actually ties themselves to the land in a substantive way such that they'll fight for British interests. So you know what we need to do? We need to give people interests in land. So about the same time that these global events were taking place and revolution was on people's lips and Britain felt that its position was going to shortly be under attack, British subjects began to try to figure out ways of making the British government and legacy a bit more sticky. And one of the ways that they did that was by giving people interest in land. And as a result, similar to today, where you want to kind of encourage your kids to go into tech, and perhaps 20 years ago, you wanted to encourage them to go into finance. And then 20 years before that, you wanted to encourage them to go into the professions. Back in the 1780s and then the 1800s, once Upper Canada was formed, what you really wanted your kid to do was become a surveyor, because that's where the jobs were. John Graves Simcoe in Upper Canada began the Great Survey. And what the Great Survey did was it divided out Upper Canada. Sorry, guys, someone needs to, I'm sorry, I'm going to get out of this and I'm going to go and put you guys on mute because someone else is not going on mute. So let's figure out who that is. It's ridiculous, guys. Like, really, just be on mute for 1 second. All right, thank you. Okay, so let me go back. Where is this slideshow? There we go. So, so John Graves Simcoe goes ahead and he says, we need to give people an interest in land. And we need to give people an interest in land because that way, when the Americans come in, they have something to lose. And so he sent the young kids of Upper Canada out into the forest. And he divided, firstly, Ontario up into concessions. And those of you who are aware, oh, why is my mind escaping me? The LRO areas that you have on Geo. He divided them up into counties. Thank you. And those counties were effectively made up by the stroke of a pen. You know, in the British and the French were notoriously bad for just drawing lines because they looked good on a random map that they had on their desk. In fact, in 1917, there was something called the Sykes-Picot Agreement, which carved up the Middle East into Syria and modern day Egypt and UAE and all the divisions, you'll notice that the Middle East, despite that being the cradle of civilization, has remarkably straight lines. And of course, that hasn't caused any problems ever since. And this is because the British basically just get rip-roaringly drunk and then draw lines. That's what they do. It's really quite amazing. And they did that as well in Ontario, which is why there is just such a mishmash of lines and everything looks straight for our counties and why the counties look as they do. Those counties were in turn divided up into lots, and those lots were then given away to people. And the whole purpose behind this was to start giving people interests in land, specifically to avoid American invasion, which was on everyone's mind. Let's go back to history for a bit, and then we're going to get back into real estate. So the American...
Hey, Mark.
Sorry, yes? Someone had a
Yeah,
question?
quick question. We're just wondering, is there a presentation that goes along with this? Because we're just seeing you.
Oh, I asked this at the very beginning, guys.
I wasn't logged in then, but I'm just looking at you and the beautiful painting in the back.
No. I have a whole presentation that's been going on with this.
It was there at the beginning, but then partway through it disappeared.
That's so weird. Here, let me try one more time. Sorry. Thank you for pointing that out.
There we go.
Oh, and really nice graphics. I can't believe it.
Yeah, so this was my little graphics for the establishment of Canada. You see, you have your French, your British until this, and then we had the Quebec Act leading. Look at this! I put a Ben Franklin revolutionary picture here, and you guys missed that. And then look at this one. Oh, you missed all my good pictures. All right, fine. So, and this was the effective land, and this is John Graves Simcoe. So let's keep moving on. Someone please just, I can't see the chat screens this time. So please just shout out if there's an issue. Let's keep moving. So now we are at the Durham Report. So what happens is the American Revolutionary fever continues to grow, particularly as they have success down south in Mexico, scaring the British, who now have upgraded their uniform a little bit, or at least so be it from the from the picture I was able to find online. And the British realize that they are going to be attacked and they really need a better defense. Or better yet, they have been attacked. They've been attacked in the Battle of 1812. But there's this belief that the Americans are going to keep trying, and they really need to actually start marshaling their forces. And as a result, in 1839, the Durham Report comes out and says, look, we have these two very distinct colonies called Upper and Lower Canada, and we should just make them one. We should make them into a single colony called the Dominion of Canada. And that's what was done in the Act of Union, which was 1840. And this was really the first time that Canada in its present incarnation came together. This is what assembled the first landmass that was Canada. And until, you can't have law until you have a defined piece of land over which the law is going to govern. And that was in fact what happened with the Act of Union. With Upper Canada and Lower Canada assembled, there was discussions for about 20 years that took place and said, okay, we have a relatively large piece of land. We've defended off against the American invasions of 1812. We have given people ownership in land. People are beginning to see this as a real entity. Who are we? What is our relationship to the sovereign, queen or king or whoever it was at that time? What's going to go on? And as a result, there was steadfast negotiation, and eventually in 1867, Canada became a country of its own with the passage of the British North America Act that established Canada as a confederation of provinces, which consisted of Ontario, which was Upper Canada previous to 1840, Quebec, which was Lower Canada previous to 1840, Nova Scotia and New Brunswick, which were also colonies of Britain, but then joined. Basically what happened was Britain took and consolidated all of its interests within the guise of North America. And the BNA Act then said, okay, you know, all of these previous colonies, they're going to become provinces of the larger Dominion, which is the federal legislation of Canada. And so from 1867 onward, there was formal recognition through an act of British Parliament called the British North America Act that gave recognition to the fact that the federal government controls all of the land of the former colonies, and the provinces that were originally individual colonies, the individual constituent colonies became provinces. And so Canada was born. The British North America Act did several things. British North America Act, as I said, established both a federal and a provincial structure in the country. We're going to talk about that in some detail. It established the House of Commons and the Senate. It's what gave them the power to operate and to legislate and to make laws that would further govern the relationship of the country. It gave power to the executive branch. Now, it didn't actually give power to an executive branch. What it did was it gave power to the Queen and to the Lieutenant Governor as the Queen's representative, as the Governor General. Lieutenant Governor is provincial, and the Governor General as the Queen's representative. And it established a Lieutenant Governor for the provincial representative. And what it said is that they shall have the rights to do these sort of laws. What happened was, quickly, an executive filled the void, and it became convention in Canada for the Governor General and for the Lieutenant Governor to ultimately respect the will of this executive, this elected group that was taken from the House of Commons. It also gave the governments, both federal and provincial, the right and power of taxation, which no doubt each of you are happy to hear about. And it established our judicial branch, the Supreme Courts, the provincial courts, and everyone else that goes along with it. And if we were in law school, I'd go into how that actually gets structured and how the courts work and everything else. But all of it stems from the British North America Act. From the perspective of today's lecture and from the perspective of most law students, and really from a historical analysis, probably the most important provisions of the BNA Act, I mean, they're all important, but the most important provisions of the BNA Act were probably Section 91 and Section 92. Section 91 delved power to the federal government, and Section 92 delved power to the provincial legislatures. So if you're wondering, and this is the beginning of why we are legislated the way we are, if you're wondering why it is, as an example, that the census is done federally, it's because the BNA Act stated that the powers of the federal parliament are, or the powers of the federal government are, to conduct the census. And similarly, the reason that there's no provincial military is because the military, militia, naval service, and defense is to be done by the federal government. Makes sense. Navigation and shipping, federal government. Quarantine, we're all familiar with that. Well, I never thought I'd have to talk about that, but if you're wondering why it is that quarantine laws came in and they were federal and not provincial upon entering into the country, it's because it was dictated by the Act of Parliament. Most importantly, from our perspective as real estate, banking is federal. All the banks are monitored federally. This is why when there's a provincial holiday like Family Day, it doesn't affect the banks. The banks only abide by federal holidays, right? Bankruptcy and insolvency, federal issue. Criminal law, all federal. Whereas provincially, they had certain powers. So they're allowed to tax provincially, borrow money for the province. They are allowed to establish hospitals, charities, institutions, municipal institutions, saloons, taverns, auctioneers, and other licenses. I guess those were the big businesses of the time. Most importantly, and this is really critical, was Section 13. And Section 13 says property and civil rights in the province. What that means is that pretty much all business, all property ownership, and all matters to do with justice through the police and everything else are done at a provincial level. All the things you regularly encounter in your daily life are usually imparted through an interpretation of Section 13 of the BNA Act, Section 92, subsection 13. So Section 91 and 92 were huge. And if you go into the case law of Canada prior to 1982, and prior to 1985, excuse me, you will find that the vast majority of people who wanted to challenge laws that they did not like or otherwise disagreed with, and were choosing to do so constitutionally, did so by claiming that the federal government, if they made the law, didn't have the power to do this. It's been granted to the legislature. Or in the provincial case, if a provincial legislature made a law you didn't like, that they didn't have the right to do this. This was the purview of the federal government. And that's what a constitutional challenge was for many, many, many years in the province, in the Dominion of Canada, I guess the country of Canada. Most importantly was the way we started to interpret the Constitution. Because in America, there is this idea that the Constitution is a perfect document, that the Constitution needs to be interpreted, that the intention of the drafters is all important. And as a result, justices, particularly conservative justices like Anton Scalia, who recently passed, and others, interpreted and slowed down progress, what I deem progress, what a lot of people would deem progress, by simply saying, sorry, the individual drafters didn't anticipate or rather plan for your interpretation. Let's go back to the original intent of the Constitution. That concept does not exist in Canada. In Canada, the BNA Act was never seen as a staid document. It was never seen as a document that was ossified and to last centuries. It was in turn seen as a living tree. That's the term that's given to it, particularly after, by the way, recent revisions in 1982, which we'll get to. The living tree doctrine basically stated that, yes, our grantors, our draftors gave us a document, but things change. And we need to ultimately take that document and amend it to circumstance that they could never have anticipated or suspect. As an example, neither the drafters in this document nor the drafters in this document could have contemplated the challenges that come with massive environmental degradation and climate change. The Canadian Constitution is, through its living tree doctrine, far more malleable to subsequent legislation than the staid document that is this. Now, don't get me wrong, this document gives the legislature authority, which can then deal with the ongoing needs. But it's possible to interpret that the embodiment of the Canadian country itself requires, in the Canadian constitutional context, a response to say something like climate change, because you can, a justice can interpret that the federal mandate of peace, order, and good government determines it. I'm not saying that that's happened. I'm just giving you an example of how the Constitution is interpreted by our justices as opposed to the American justices. And this, again, stems from the BNA Act, whereas the American authority stems from the Declaration of Independence. All right, so you may have noticed that I have now talked about, by the way, I'm so glad that you're now seeing my little slides, because if you can't get a slide in of Ron Burgundy, are you really giving a presentation? All right, so we've now talked about the federal government, we've talked about the provincial government, but you may notice I haven't yet mentioned the cities. So where does this leave the cities? Well, quite frankly, if you ask the cities what they are in Canada, if you ask people in Toronto, how important is Toronto to Canada, you get the Ron Burgundy report in response. I don't know how to put this, but I'm kind of a big deal. Toronto believes it's the center of the world. Probably rightly so, frankly, given the amount of commerce that takes place in the GTAA, which probably is outside of Vancouver and Montreal, and maybe some gas that comes from our friends in Calgary or in Alberta. It's probably true. I mean, the vast majority of our industrial and commercial output really takes place within the GTAA. So having that in our own mind is probably correct. But actually, the cities, from a legal perspective, are anything but empowered. They're anything but Ron Burgundy. They are merely creatures of the province that we reside in. So let's take the city of Toronto. The city of Toronto exists because the province, through their authority in Section 92, simply passed a law. And the law in this case was called a law to erect the town into a city, to erect this town of York into a city and to incorporate it as Toronto. That's the reason Toronto exists. It's because the province said, we have all this power under Section 92. We are passing a law and we are just making the city of Toronto. City of Toronto does not have any standing under the BNA Act. It has no authority under the Act. It just is. It exists at the whim of the province. And so you may know that recently Toronto's acquired Land Transfer Tax Authority. How did they do that? Well, because there was a change to the City of Toronto Act, where the province said, hey, you know that power we have right here, direct taxation within the province? We're granting it to you, City of Toronto, for the purposes of collecting land transfer tax. The reason Ottawa doesn't have one, the reason Kingston doesn't have it, is because the City of Ottawa Act, because the City of Kingston Act has not been changed, and thus the provincial power has not been granted. The cities are totally powerless unless a province gives authority to them to act. Does that make sense so far? I'm going to pause for a minute. Anyone want to shout out a question, or are we good so far?
Can the legislature then take that authority away at any time?
Anytime, which actually happened when when Doug Ford became premier. Many people thought that Doug Ford became premier because he wanted to be mayor, or he wanted to do what he could not do as mayor, what Rob could not do as mayor. So when he came in, he immediately changed the voting makeup of the City of Toronto over the City of Toronto's objections, right? He went ahead and he cut the amount of councillors down by half, just because he never liked that amount of councillors when he was a city councillor himself. And was he allowed to do it? Sure. The City of Toronto brought an application and tried to challenge it on constitutional grounds and said, we're in the middle of an election. What the heck is going on? They can't do this. And the court said, he absolutely can. You are totally a creature of the provincial power. And if he wants to step in and micromanage the cities through the act of parliament, he absolutely can do that. And so we saw that.
And that wasn't.
Sorry?
That wasn't done through the executive. That was done through the legislature still.
That was done through an act of parliament. That's right. They changed it through an act of parliament. But the executive is often authorized to act. So oftentimes the way the executive works is that these acts basically said, and the lieutenant governor shall be permitted at their discretion to do X, Y, Z, which is called an order in council. And if the act has permitted the executive to act, then the executive can just pass an act of parliament, of cabinet, and suddenly it is so because the act is already in place. That's not what took place during the election reform, which required an amendment to the City of Toronto Act, which was passed. Make sense?
But that would be, as any secondary legislation, that would be amenable to a judicial review, which is why Toronto went to court. Is that,
well, yeah,
am I getting?
Anything is subject to judicial review, but Toronto went to court on a constitutional basis and was quickly found, as was expected, by the way. The City of Toronto didn't expect to win it. They had no constitutional basis. The province of Ontario is allowed to do what it wants. City of Toronto, province of Ontario can simply take the City of Toronto and tear it apart or smush it together. During Harris's time, they passed a law that said, hey, you know all these different cities, East York, North York, Toronto, smushing them all together. And the municipalities roared and said, we don't want this. And they said, too bad, done. Remember that?
Yeah, Metropolitan, the municipality of Metropolitan Toronto.
Right. But that was purely a provincial creature because the province can just do anything they want to cities. Cities have no constitutional standing. Make sense?
I'll be quiet now. Thank you.
No. This is a good question. Okay, now, not everything is Toronto. Some municipalities, some cities, some towns are very, very small. And, you know, if you're talking about a township of like 1,000 people, putting in the necessity of collecting taxes, of doing planning, of doing social services, of making sure that the ambulances run, I mean, it would totally overwhelm them. And as a result, for a lot of non-single tier municipalities, so Toronto, Ottawa, those are examples of single tier municipalities. Within the municipality, so what I'm talking about now, I should contextualize. So the province of Ontario granted certain places city charters, and those cities are single tier, which means they contain a whole bunch of powers that the municipality itself is able to dispense, granted by the legislature. So we talked about the power of land transfer taxation for the city of Toronto. But normally a city has the right to do their own planning, to do their own tax collection for property tax, to do their own municipal work planning, to do their own, and so on and so forth. But there are certain townships that are so small that if we were to foist all of those responsibilities on a township, they would be overwhelmed. And as a result, the province has also allowed for double tier municipalities. And what those are places like places that have a large region, which basically develops ideas for planning, social services, and works for a whole bunch of towns. And then the townships themselves, which then deal with the specific needs of that small town. And that's the difference between a single tier and a double tier municipality. Single tier municipalities generally are large enough such that they want and can maintain control over the entire municipal process, which we'll talk about shortly. Whereas double tier municipalities are dealing with townships that are usually so small that collecting them into an organization called a region makes sense, and allowing the region to deal with all of those townships collectively is just a better use of time and resources. Does that make sense? So the province of Ontario devolves its power both to individual cities, to regions, and to townships, depending on the population base that exists then and there, reevaluating every couple of years, because as things grow, obviously things change. So as an example, the city of Toronto became a city in the 1800s. Before that, it was a township itself. And as things grow, they get more responsibility and switch from double tier to single tier townships and the like. Province of Ontario also, I'm sorry, I don't know where this came from. I have been using it for years and I don't remember where the source is. I wish I could source it. But the province of Ontario also ensures that regardless of what you're in, whether a single tier or a double tier township or anything else, that it controls the larger principles of growth that everyone is involved in. And so it passes large provincial statutes like the Oak Ridges Moraine Conservation, the Places to Grow Act, the Planning Act, the Greenbelt Act, the Niagara Escarpment Act, the Ontario Planning Development Act. There's been subsequent ones. This is now aged. I think this was dated from 2017 or so. It actually has grown since there's more acts. But regardless, these statutes are statutes that are passed by the government. They say, listen, we're giving you guys, the townships, the cities, everyone else, we're giving you all the authorities you need. But occasionally we have larger principles that everyone needs to adhere to. We want to see the Oak Ridges maintained. As a result, we're passing legislation, and everyone, regardless of where you are, must adhere to the Oak Ridges Moraine. It supersedes the City of Toronto Act. Same with the Planning Act, same with the Greenbelt Act. These are large planning statutes that govern how all of the provincial powers that have been devolved have to ultimately accord with the larger environmental and planning purposes of the province. And I could go into this in some detail, but basically this is for another day. I'm just pointing out that the fact that the province has devolved power doesn't mean that they've devolved all authority. They maintain broad strokes, broad brushes behind which everything can be planned. I just produced this PowerPoint and I had to pick this background image, this light blue that you see in the background. That light blue exists for all slides. And it's a bad example, but that light blue is the province. So the city can do whatever they want on the background, but the background itself remains in control by the province, and they can pass these acts that fundamentally carve out and mandate how it is that people need to act within their provincial powers. Make sense? Okay, let's go back to history. So the Constitution, so the BNA Act was pretty good. And the BNA Act was not a single document. Some select examples of things that happened was that, Canada started changing. And so the BNA Act needed to be amended, always by the British legislature. So in 1907, transfer payments were allowed. And in 1915, the Senate's moved, the Western provinces started developing. 1930, British Columbia, Alberta, Manitoba, Saskatchewan really kind of came into their own. Federal employment insurance took place after the Great Depression, and 1940 was there. 1949, Newfoundland grants access as the final province into Canada. I just picked a couple of select ones. And you can see every couple of years, the BNA Act was being updated. And in every single instance, the British Parliament had to pass legislation bringing this change, because the BNA Act was, after all, our Constitution. And in 1982, and I'm going to stop for a second. In the 1930s, there was something called the Statute of Westminster that was passed. And the Statute of Westminster said that anyone who is a British colony who wants can get authority and become their own, can patriate their own constitutions, can actually start taking on authority such that they no longer need acts of parliament such as this. Canada made a decision, partially because it was at an odds as to how to proceed, to delay that power and continue to go back to the British Parliament for this update and authority, until in 1982 they decided, okay, we need to come into our own. And in 1982 the Constitution Act was passed. And what the Constitution Act is it basically said all of the previous BNA Acts of 1867 on down, all of them are part and parcel of this particular act. So now we don't call anything the BNA Act. We all call it the Constitution Act, because it was all subsequently renamed to the Constitution Act. And the Constitution Act did two major things. First, it took all the BNA Acts, made them one under the Constitution Act, and gave a new authority to the parliaments of Canada, where they were allowed from henceforth to make their own decisions on behalf of themselves. No longer did they require an act of British Parliament to ultimately amend their constitution. The Constitution patriated the Constitution. It made it such that Canada itself could be in control of its own constituting document. A huge matter. Now, if we want to make amendments to our Constitution, we can do so without any British interference at all. It also passed the Charter of the Rights and Freedoms. The Charter of Rights and Freedoms, I want to make this very clear. The Charter of Rights and Freedoms protects people in Canada as against the federal and provincial government only. If I go ahead and call someone a racist name, the government is not involved in that action at all. If I deny someone housing, the government has nothing to do with that. It is not a charter violation for me to do any of that, because the Canadian Charter of Rights and Freedoms, unlike the amendments in the States, the Canadian Charter of Rights and Freedoms protects us as against federal and provincial government intrusion alone. And what does it do? It guarantees us, and we didn't have this until 1982, and it came into effect in 1985. So from 1985 on, it was passed in 1982, scheduled to come into effect in 1985. And so from 1985 onward, we had the right to freedom of conscience, religion, thought, belief, opinion, expression, peaceful assembly, and association. In other words, the government cannot stop, except as subject to required as reasonable in a demonstrably reasonable in a just society. The government cannot stop people from having freedoms of conscience, religion, thought, belief, opinion, expression, peaceful assembly, and association. By the way, I'm just going to stop for a minute. I know that this isn't what we're here to talk about, but I was once listening to someone who I used to very much respect, and he was giving a talk, and he tried to explain. This was in the time of American curtail of fundamental freedoms, just in the wake of 2001, and he was trying to explain what is it that's so important to have a freedom of thought, belief, opinion, expression, peaceful assembly and association. And he said this, which I think was very apt, and I've never forgotten it. He said, "It is in the freedom of thought, belief, opinion, and expression. It is in the privacy that is accorded to you to make your own decisions that we are in fact born." People try out many faces, many personalities before they decide what they want to reveal to the world. And you are not allowed to become the person that you become without that freedom. If everything you do involves the state watching you, then you can never really explore who you want to be, and thus you become a very different person as a result. Section 2 is a fundamental freedom. The right to privacy from the state is a fundamental freedom. It allows us to define who we are, who we want to present ourselves as, and as a result, this is the type of society we eventually become. Go to an authoritarian state, I've been to many, and see what happens when that fundamental freedom is denied. It's critical. Citizens also have the right to vote. They have the right to remain or leave Canada. They have the right to life, liberty, and security of the person, reasonable search and seizure, criminal rights. Most importantly, from the perspective of law, there was equality rights that was granted. I mean, not if you're Aboriginal. If you're Aboriginal, you care about Section 25. But equality rights of Section 15 and Section 28 with gender equality really became the focus of the courts after 1985. It was the case that the government was not allowed further to discriminate on people on the basis of sex, could not discriminate on the basis of gender, could not discriminate on the basis of religion, could not be discriminated on the basis of ethnic origin. And in fact, many of the subsequent pieces of legislation, gay marriage and the like, that took place, foisted themselves on the back of Section 15 equality rights, because there's an analogous ground there that says any analogous ground is also included. And so anything that the charter drafters did not think of is also something which the courts can interpret to be subject to equality rights. Basically, what they're trying to do is get the government, federal and provincial, to treat people equally at all times. And in fact, it was only upon the passage of the Canadian Charter of Rights and Freedoms in 1985, the implementation of the Canadian Charter of Rights and Freedoms, that we realized exactly how unequal Canada was as people began bringing suits all over the place, and most of them were found to be correct. But of course, this doesn't address the fundamental problem that exists as that you experience as real estate agents all the time. Because as real estate agents, you're not dealing with objections against the government. You're dealing with people who are fighting one another all the time. You're dealing with a landlord and a tenant. And again, the Charter of Rights and Freedoms only protects people as against the federal government and the provincial government. So what stops people from ultimately discriminating in tenancy? What stops people in discriminating in employment? What stops people from being racist? What stops people from doing anything between one another? Well, the answer is that the Ontario Human Rights Code protects people from discrimination against other people with regards to accommodation, contracts, employment, services, and membership in union. You'll note it doesn't stop people from being racist or from having racist beliefs or from actually expressing those racist beliefs. You are allowed to stand up on the street and call me, I'm Jewish, call me a kike. You can do that. You are allowed to do that. There's nothing illegal. There's nothing contrary to either the Charter of Rights and Freedoms or the Ontario Human Rights Code. I mean, what type of person that makes you is a completely different matter. But there's nothing in law that stops you from expressing or even holding those beliefs. But you cannot, if you hold those beliefs, actually apply them to accommodation decisions, contracts, employments or goods, services or facilities, or membership. What's more, the government certainly can't be applying that, or any quasi-government agency cannot be applying that because of the Charter of Rights and Freedoms. And so that's as good as it really gets at the present time. Sorry, someone's off. Someone needs to take themselves on mute.
So small wonder that the
All
author
right, all right, let me figure out who this is. I'm calling you out this time, I think. Oh, okay, you're there. All right. So how does this apply? Let me just go back to this. How does this apply? I know we're coming up to the end. How does this apply to real estate? Well, you guys know that we have a whole bunch of boards and a whole bunch of organizations we belong to. We belong to the OREA, we belong to RICO, we belong to CREA, we belong to TREV or whatever our local real estate board is. Where do these derive their authority from? Well, actually, interestingly, there is only one entity that has the ability to govern real estate in Ontario, and that is the provincial government. The provincial government has the right to establish institutions in the province, has the right to ultimately allow for property and civil rights in the province, and can incorporate companies with provincial objects. Effectively, the province has the right to regulate everything that we care about with regards to real estate in Ontario. And the province has given that authority through REBA, through an act of parliament, to RICO and RICO alone. See, it has that little bam there, that little Batman bam. That's because the OREA is a functionally useless entity from a legislative perspective. And CREA, the Canadian Real Estate Association, has no legislative authority whatsoever, nor do the local real estate boards. None of this is the basis upon the power that we can trade in real estate. We can trade in real estate because there was a passage of the Provincial Act of Parliament. They could pass that act because they were given the authority through the BNA Act, subsequently the Constitution Act, which said that they have the right to property and civil rights in the province and the regulation and administration of provincial activities like this. And they gave that authority to RICO. And RICO is responsible for regulating professionals in the province and for mandating education. RICO, in turn, provided authority in previous years to OREA to do education, and then recently withdrew that right. And so OREA has since been searching for a raison d'etre to exist, and thinks that it has found it, at least Tim Hudak thinks that he has found it, in the form of a lobby organization on behalf of realtors in the province of Ontario. And similarly, RICO allows for anyone to practice real estate as they like, which meant that a whole bunch of people who were registrants then decided to self-organize, and they established their own boards. And those boards, in turn, functionally voluntarily adhered to become members of CREA. CREA, which is the Canadian Real Estate Association's point, is twofold. First, they produce a whole bunch of forms. I don't know why they do that and not the OREA, frankly. But the OREA does their own forms as well. But CREA is there to lobby the federal government on behalf of realtors across the board, because as you're aware, something like banking remains a federal jurisdiction. And as a result, if we're talking about interest rates, it's not OREA that is going to be lobbying the provincial government, it's CREA that is going to be lobbying the federal government, because they are the people who are in charge of banking and banking issues. So what the local boards have done is they have empowered CREA, the local boards that derive their authority from RICO, which derived its authority from REBA, which derives its authority from Section 92 of the Constitution Act. The local boards have joined CREA, giving them credibility in negotiating with the federal government for federal matters. And that is the way real estate is organized in Canada. And that is the reason it is organized this way in Canada. It is simply because it is a historical remnant of the Constitution. And the Constitution has provided the province the power, and the province has in fact delved that power over to RICO, similar to the way that it's delved that power over to the city of Toronto for the purposes of regulating the city of Toronto's space. That is how this all works. So we have 3 minutes left. Who has questions? Just shout them out.
In relation to the Ontario Human Rights Code and the Canadian Human Rights Act, which of the legislations would you say CREA would be amenable to?
Well, CREA is not amenable. CREA is an organization. So CREA, when it functions in Ontario, is subject to the Ontario Human Rights Code. When it functions in Quebec, it's subject to whatever the Quebec version is. It is a private organization.
So it wouldn't be necessarily subject to Canadian.
Not subject to the charter. Look,
Canadian, not charter, because the human rights legislation has a counterpart at federal level, which is the Canadian Human Rights Act.
Yes, it does, but it would be subject to the provincial human rights code, because it would be employment-based issues, or it would largely fall under the Ontario Human Rights Code. There is part of constitutional law, part of studying constitutional law is understanding exactly how far things like the charter extend into private organizations. So as an example, what about a crown corporation, something that is an act of parliament, like the Oak Ridges Moraine Act? If there's an organization that's there to govern the Oak Ridges Moraine by virtue of the act, are they subject to the charter? The answer has been found to be yes. What about an association that is largely about satisfying a federal end? Well, the courts have interpreted what the charter itself applies to. And similarly, they've determined what the human rights codes, federal and provincial, have applied to as well.
Yeah, but I'm not talking about the charter. This is not the charter. This is the Canadian Human Rights Act, which is dealing with human rights, dealing with this issues of discrimination and access. And
I'm aware, Vladimir. That's why I said similarly. They have developed out laws that pertain to the human rights codes and what they pertain to as well. So what you're asking about is a large organization, and you're saying which one of these laws pertain to it. And I would tell you that it was largely done through the provincial human rights codes, but if there are exceptions to this. This is the whole thing about being a constitutional lawyer. There are exceptions, and in certain instances, other acts may apply, and you have to kind of answer this on a case-by-case basis, and you have to look into it. But generally, it would be the provincial human rights code that would apply based on the province that is being engaged in.
So if one were to raise an issue of discrimination or accommodation, as it may be, with CREA, even though it's a national organization of realtors, that issue would have to be solved according to the Ontario Human Rights.
Like think about this. Like Microsoft is in all provinces. It may be federally incorporated, but if Microsoft chooses to discriminate against me in a contract, I bring the claim under the Ontario Human Rights Code.
Yeah, that makes sense. Will you take another question from me?
Well, let's just see if anyone else has one, and then I'm happy to take another one from you.
Sure.
Anyone else, guys? Okay, Vladimir, go for it.
Yeah, so what is your take on this Dyson concept that Parliament can make it and make any law in relation to the Constitution Act? Is that still treated like an ordinary statute, or does it have the status of constitutionally entrenched one?
Okay, can you explain one more time? I'm sorry, I didn't quite understand the question.
So in the British constitutionalism, the A.V. Dicey, the scholar that came up with the concept of parliamentary sovereignty, by which Parliament is capable of making and unmaking any laws and cannot bind its successors.
Oh, I see what you're saying.
So from that perspective, what is the status of the Constitution Act of 1982? Is it considered an ordinary statute for that purpose?
No, it's not. The Constitution, I mean, I haven't addressed all the points of the Constitution, but to your point, the Constitution actually makes for an amending formula in addition to everything else, which requires provincial inputs, and it's very complex, but it is a superseding law. It oversees all other laws and can only be amended in accordance with its law, which stipulates a heightened responsibility. It's not an act of parliament. It requires provincial approval as well. In fact, you may remember Meech Lake, and you may remember the Charlottetown Accords. That was trying to get the provinces on board with constitutional change, with further changes to the Constitution Act, because the Parliament itself could not change it. So Parliament has in fact bound its hands as regards to the Constitution Act going forward. And everyone has agreed that that act alone has the authority of a constitution, meaning that it has to be amended in accordance with its terms, which again are more than a simple act of parliament.
I'm going to be listening for, and maybe you can touch upon it if you haven't covered it in your points, but then I'll ask the question later as to how it relates to the Bill of Rights of 1960 and whether it is considered impliedly repealed by introducing the charter.
So I'm going to answer it now because we're at 11:02, but no, it's not, because the charter deals only with governments, and the Human Rights Code deals with something completely separate, which is the rights of individuals between one another. They are totally separate jurisdictional areas.
So Bill of Rights deals with, so the Diefenbacker's Bill of Rights deals with individuals, not governments?
Oh, you're talking about the federal. They tried to pass. That is a bit, there were certain amendments that were made to the bills that took place between 1982 and 1985 to actually make the two fluent with one another. I'm not going to go into it. It's way too granular.
It's just that there's a lot of misinformation. There's a lot of legal fiction in certain groups about how, the Bill of Rights work, as, whether the charter works or whether the Bill of Rights work. And I just wanted to hear from you how you see that. This is
not, unfortunately, it's way too broad right now, and a topic that I'm trying to tackle, and it's a very specific question. With your permission, Vladimir, I'm going to leave it out.
Thank you. I know, I appreciate it. Thank you so much.
Does anybody else have any questions? Are we good? Okay, guys, thank you as always for attending. This will be up online, and wish you guys all the best.
Okay, thanks again.